You're listening to the Abolitionist Roundtable, patriotic Black American conservatism, with your hosts, Del, Phil, and Janice, leading the charge and advancing the 4%. Join in the conversation at 734-822-1600.
And we are back, and as promised before the break, we have on our hotline this morning from the Thomas More Law Center, the lawyer that was part of the litigation team for the 100 pastors in Michigan. But let her do that. We have on our line Erin Marsino of the Thomas More Law Center. Good morning, Erin.
Good morning, Phil. How are you doing?
Well, I am doing so very well this morning because we are so glad to have you back. What I believe it was the 16th of May that you were on, and the court case had not been litigated. And so we see what my major fears was that they would rule as they did. And first of all, again, welcome to the show. And I know that you were ecstatic at being in front of the Supreme Court, but to lose a case like that, does that make you feel any more sadness or anything like that, like I feel?
Yes, someone was talking to me and they compared this to having a relative and finding out that the relative had terminal cancer.
Yeah, that's about a good analogy.
Living with that for years, yeah. And then when the relative actually passes away,
yes,
there's such a loss. So even though it was known that it was coming, it was still just such a horrible loss when the day actually came. And I think that is such a good analogy because it's certainly how I felt. And it seems as if you are saying that you have similar feelings as well.
Well, we have in the studio with us this morning Pastor Richard Dietering, and I'm sure that well, I don't know how much of the show you were able to listen to this morning, but I'm sure that he feels your same sentiments on that situation. Pastor Rick, I know you said you wanted to ask her about something right quick.
Well, I just wanted to find out what you think of what's happening with this couple in Oregon. I see this really as stomping on their First Amendment rights. I don't know if you're familiar with the case at all. They refused to make a cake just because they did not want to participate in a same-sex marriage. Their religious belief says that they can't condone such an action, therefore they cannot participate. So they didn't, and now they're losing their home, their business, and everything else because of the state law in Oregon.
Yes, no, I'm very familiar with Aaron and Melissa Klein and the fine of $135,000
yes, right,
that the administrative court dealt to them, and the fine was based on emotional damages of the couple for having to go to a different baker. It's astounding. And then the gag order from the court silencing
yes, right,
their speech. And I loved their reaction that they immediately went out and defied the gag order because it is unconstitutional and it's insane. And I know that the attorneys in that case are appealing.
Well,
and it's just so unconscionable. You would think that the court would do the right thing.
Yeah, that's why I wanted to lead off with that question because if you notice up to this being taken by the Supreme Court, there always was a thing where it was said that because of the vote in California, that it should have been a significant understanding that people just did not want this type of legislation. When in California, you can get people to vote against the marriage the marrying of gays. In an election when Barack Obama won significant numbers in California, they were still able to pass that saying that they did not want this. And then for the courts to overturn it, what was said nationwide was you can't use constitutional law to take away the civil rights of others. That's what people were saying. But we see that the civil right to marry has turned into taking the constitutional rights of people that adhere to religious beliefs. This, to me, is a shakeup of proportions that rock the world, because here we see we have absolutely no recourse, because if you pass legislation that says, even if you get a constitutional amendment, if you say that you want to protect religious liberty, then there's the danger of the Supreme Court knocking down whatever legislation comes about because of the power of the courts.
Erin, can I ask you a quick question on all this? A lot of time on the First Amendment is talked with the Establishment Clause of religion in the First Amendment, but we don't get much into the free exercise part of that.
Yes.
How does that part of the First Amendment play into all this, the free exercise of one's faith?
It's vital. I mean, it's very interesting because in the Supreme Court, the free exercise clause was rather mishandled. And there's a case called Employment Division versus Smith, where the court really kind of eroded at what the free exercise clause was meant to do. So then Congress went and they passed it was a huge bipartisan effort. It was signed into law by President Bill Clinton in 1993, the Religious Freedom Restoration Act. And what that did is it preserved the standard for the free exercise clause that we used to have before that bad case, Smith. So that gave us the right to have our free exercise protected. It protects it broadly, and it's a wonderful law that we've been able to use in the courts in cases like Hobby Lobby, where the government will come down and say, business owner, you need to provide contraceptives, then you need to provide abortion-causing drugs. And the business owner says, no, I can't. That's a substantial burden on my faith. Yeah. If I do that, I'm going to be violating my religion. Then the mechanism that protects that religious freedom is this Religious Freedom Restoration Act. In most states, the states have individually, because that was a law enacted by Congress, it only works for federal law. So when the state comes down and passes a state law that violates religious freedom, then the states individually have enacted their own version of that federal law. But not all states have it. Mm-hmm. And here it really shows that there is a need to have that protection, because that protection will help individuals, especially in cases like in Oregon, where you see Oregon has a law saying it's a Public Accommodations Act law, saying that you can't discriminate on the basis of sexual orientation. Well, this isn't really discriminating on the basis of sexual orientation. I know in that case they'd served the couple, several times. It's just being a part of, promoting the union between homosexual couples and being part of that ceremony. That's something that they can't do that violates their faith. So in states that have a version of the federal law that protects religious freedom, then at least there's going to be that defense and there's going to be that claim to protect them. In some states, though, the law doesn't exist.
Well, here's the thing. Most of this is a result of public opinion. And public opinion is being, the religious speech is being curtailed. And in some cases, in the case of where they put the gag order on these people, it is absolutely being taken over by the government. The government is telling these people, you have got to be quiet. But when somebody says what they feel is infringing on their rights, they are called homophobic. They are called all kinds of names, and are allowed to. So, if you're going to allow one person to curtail another group's speech, what is it that that a person can do to defend the well-meant intentions when they exert their firmly held religious beliefs, and they're called bigots and homophobes?
Yes, even in the Obergefell opinion, there's two sentences in there talking about First Amendment freedoms,
mm-hmm.
and saying that, okay, even though we're deciding that same-sex marriage is going to be recognized, they also say that, of course, anyone has First Amendment freedoms to speak out and discuss their religious beliefs. And I would say that really wasn't as broad of a protection
yes.
as the Constitution mandates. But they did make some mention of it. I think what you're saying, too, though, with the popular opinion, there is this huge movement to shut down anyone who has any sort of dissenting viewpoint.
Mm-hmm.
And I think that, that's always been used, the name-calling, the ad hominem attacks. That's always something that's used to shut down any sort of valid debate, and it does so without any support of their argument. So, unfortunately, the word bigot was all over social media the day that this opinion came out.
Yes.
But I think we have to work past that, because it's completely untrue. There's no hatred whatsoever from people on our side of the issue.
I see. To me, this is totally a spiritual struggle that's going on in our nation. That's how I see this. But it's been handled through the legal system.
Yes.
Now we've had the Supreme Court that came through and made this decision that went against the vote of the people in a number of states. California and Michigan both voted to not have. Well, actually, Michigan voted just to define marriages as between a man and a woman.